Supreme Court of Florida is now in session. Please be seated.
The court will now take up the third case on our docket today, Booker versus the state of Florida.
May it please the court. My name is Megan Long. I'm with the Public Defender's Office for the Second Judicial Circuit, and I represent the petitioner, Reginald Lee Booker III. I reserve 5 minutes for rebuttal. Your Honors, this court has already determined that the 22-point rule sentencing statute is unconstitutional, and today the issue before the court, it's a certified question of great public importance, is what is the remedy for that? Before I get to my argument on the remedy, I want to address the state's motion to dismiss. This issue is not moot just because my client has completed his 4-year prison sentence. This issue is going to keep coming up.
Why is that? So if it's brought up, if it's preserved, as it should be, directly, and it's a 5-year sentence, someone increases from non-prison to 5 years, it'll make its way through in time. The only reason this is not the case is because this was brought up in the context of a 3800. And in that context, it's done pretty late in the day, and it's hard to work its way up through the appellate process. I'm wondering why you think that's, in other words, this isn't like a 1 or 2 day jail sentence where it's always going to expire, right?
That's correct. He received 4 years.
Right.
But I want to emphasize to the court how rare that is. Many of these sentences that this class of defendants are receiving are not much longer than 11 months and 30 days. So I submit it's pretty rare for a client to have a 4-year sentence and still be serving it at the point here he was in prison when the jurisdictional briefs were filed. Because remember, over the years...
It's not that rare. I mean, Mr. Brown was still serving, right?
He was.
Right.
But it was very hard.
I have to tell you, I served as a trial judge, not all that long, but long enough where I've sentenced a number of people. I've never heard of this statute until I read Justice Lawson's opinion some time ago. Maybe this is more common up here, but how common is this done in the Second Circuit?
In the Second Circuit, so in 2012, one of my first cases was a defendant who, he received the most I've ever seen, 5 years. He went to trial. He was acquitted of some second-degree felonies, but he was convicted of felony criminal mischief. I raised this same exact issue. This court held it unconstitutional in Brown last year. But me and other attorneys at our office, we were raising this issue, but remember, the DCAs weren't reaching the constitutional issues. If a person got relief, it was because they said the trial court,
had not made appropriate findings or...
Right. But we were also getting non-written opinions, and we can't review those here. So I submit that it is pretty rare that we have a written opinion at the time that the jurisdictional briefs were filed here. You have a client actually serving the sentence, because with gain time, with credit for time served, it is pretty rare. And the fact that he was serving the sentence, is, the original basis for the jurisdiction here, I think if the court doesn't decide this today, it's going to be tough to get another case like this. And again, now in the first DCA, this is happening again. We just got a record here, Your Honor, where a client has 20 points and he got a prison sentence. The same thing that the legislature wanted to prohibit.
Is there any, can you think, and I honestly don't know the answer to this, is there any collateral consequences that would result from having the 5-year as opposed to you guys call it 1130, we used to call it 364, but an 1130 sentence?
A collateral consequence?
Yeah, like would it affect any HVO or PRR, that it's a prison as opposed to a jail sentence? In other words, is there any potential collateral consequences? Trying to help your case here.
Yes, if the person is released from a prison facility, and now he or she could be subject in the future to HFO or PRR.
In fact, in the PRR context, we've said that release from a county jail is not, it has to be actually released from a prison facility, correct?
So yes, Justice Luck, and in addition to the fact that the legislature says this type of person, this class offender, is not supposed to be in prison, not only it's a significant liberty, they thought they were going to get probation or community control or 1130, and they're doing now 4 years in prison. But yes, future collateral consequences.
For this particular defendant?
This particular defendant, yes, because he walked out of a prison facility.
Okay.
Of course, he's out now. Of course, we're arguing sever that second part of the statute, but if this court goes with the reverse and remand to the lower court to have a jury make that dangerousness finding, he's out now. He can't get remanded.
Yeah, but if he committed
I'm sorry,
another
Your
crime
Honor?
within 3 years.
I'm sorry?
Am I off? No, I'm on. If he committed another crime within 3 years, another felony, the PR statute would apply.
Yes.
Just a little thing.
Yes. So there are collateral consequences.
Thank you. I just wanted to raise those for mootness issues. Please go ahead with the rest of your argument.
So I've supplemented the authority. I believe this case is still properly before the court. It needs to be decided today. Lower courts need guidance. And as I told Justice Luck, we just received a record in our office where now trial courts are doing exactly what the legislature did not want them to do. They're giving people with 22 points and under prison sentences. So the very discretion that the legislature took away in 2009, in the first DCA, the trial courts have that back. So as to the merits, we set forth 2 remedies in our brief. The one we think is best is to sever that second sentence of subsection 10. And if the legislature wants to come back next session or whenever and create a constitutional safety valve provision, they could do that. They could simply change court to jury if that's what they want to do.
Isn't the purpose of all of this to effectuate the legislative intent or legislature's intent with doing as little damage to the statute? You agree that's the general purpose of what we're trying to do?
Yes, Your Honor.
How does severing it out completely and just waiting for the legislature to come back do that when clearly they wanted some mechanism to sentence above the 1130 or the non-state prison sanctions?
Justice Luck, I don't know from the legislative history that it's clear that they wanted to have this safety valve provision such that they wouldn't have passed the first part of the statute without it.
Well, we know they put it in.
Right.
They
So,
put it in.
but I mean, even more than that, I mean, yes, I think the chief is exactly right. But even before that, as I understand it, and please correct me if I'm wrong, it existed like it is now, meaning it was always 0 to 5, essentially.
Well,
And-
the statute didn't exist till 2009, but under the criminal punishment code,
Right.
a third-degree felony, it's 0 to 5 years.
Right.
So obviously, yes, Chief Justice Kennedy, it's in there.
So it was always 5, and then what happened is the legislature said, well, for 5 really isn't appropriate for some things, but we want to leave a safety valve for trial judges to do so for worst-case scenario defendants. For those that are dangerous. And so we're saying, no, it's capped here, but the trial judge can do so if certain findings are made, right?
Well, I disagree
Okay.
on the legislature worrying about dangerous offenders going out in the community under the statute, and I'd refer the court to that legislative analysis. It's a budget bill. It's cited in the state's answer brief. If you print out all of it.
I understand that, but the statute itself says that a trial judge, based on a finding that defendant is a potential danger,
Yes.
that they could sentence more than that, correct?
Yes.
That's pretty good evidence of legislative intent that they cared about those who potentially were dangerous to the community, right?
They did, but I think that's why in the first part of the statute, that whole separate sentence, they exempted forcible felonies and they said people for Chapter 810, if it's burglary of a conveyance, burglary of a structure, possession of burglary tools, those are the class of offenders that the legislature said these people are dangerous. Or
So
they
I have
could
no
be.
doubt in the panhandle that the vast majority of murderers and PBL defendants are serving significant sentences, but at least where I'm from in the state, there's a lot of folks who have very serious crimes who are still walking around because of the sentences they received. If one of those individuals commits a criminal mischief that for whatever reason, because of age or otherwise doesn't score very high, why is it not appropriate to sentence for a judge to say, you know what, this person maybe should have more time than 364?
I think when this statute was passed, and I think this is in that budget analysis, when the legislature said they could have made it a lower point total, but they made it 22 points. And I think the legislature, by doing that, they anticipated people like my client. If you look at his score sheet, he has a supplemental sheet on there. There's a few different offenses. They anticipated people who had some sort of criminal history, maybe 5 or 10, pretty low-level stuff.
I guess what I'm saying is that this is done not infrequently, as you've articulated here well, and this is an important tool. How does taking that tool out not contrary to exactly what the legislature wanted?
Well, I think what the legislature wanted first and foremost was to address the financial conditions in 2009, because on the very first page of that analysis, says we are facing for fiscal year 2009-2010, Department of Corrections has a $7.3 million budget, and there's only two options. We can put less people in prison, we can build more prisons. We don't have money to build more prisons. So they have data from a few years that says trial courts, those judges could be sentencing people, up to 44 points. They could be sentencing them to a non-state prison sanction.
But you're essentially asking us to conclude that they would have done that even if they could not protect the public from dangerous people while doing it.
Well, absolutely, I am arguing that, Your Honor.
Yeah. So,
Because whether or not that
seems like a
second-
stretch to me. I mean, they did pass it. It's the way they passed it. And that protection would just seem to me to be very important.
Well, I think it's important to realize
And there is another alternative.
there is.
Yeah.
I'd be happy with that too.
Okay.
But I think it's important to recognize when the legislature looked at this, they weren't saying people that otherwise could be getting a non-state prison sentence are getting a prison sentence because courts think they're a danger to the community or a danger to the public. What they're saying, and it doesn't say why, it doesn't say what data, but they said anecdotally they've received reports trial judges are putting these class of offenders in prison because there's not a diversion program, or their bed's not available, or the local jail is crowded, and they don't think this person can serve a jail sentence. And that's why they were putting those people in and sentencing them to prison sentence, not because there's anything in the legislative history that says we think a lot of these trial judges think these people are going to be a future danger to the public. I think that it is a safety valve provision, and yes, of course, they were passed together, but the legislature's main goal here was to take away the trial court's discretion to say, we've decided 22 points and under, these types of felonies, they shouldn't be in prison.
Isn't the second remedy that I believe both you and the state bring to us one that seems to effectuate the concern for those that are truly dangerous, and yet provides the Sixth Amendment Apprendi right, which we're all concerned about,
Yes,
and that
Your Honor.
is having a bifurcated trial or having some sort of jury finding that the judge then within its discretion can decide to impose or not impose.
Yes, Your Honor. If this court would read into the statute court as a jury, again, this would be a very small amount of people that didn't work out a negotiated plea or they're not stipulating that they're a danger to the community, people going to trial. The jury's already there, it's already in panel, they're going to make the finding. But again, I just want to emphasize, I think the legislature took care of the dangerous, violent felons in the very first sentence of that statute because it exempted the forcible felonies. And I think the legislature looked at it and said, people, even if you have 22 points and you have a fleeing and eluding, the legislature looked at that and said, that person doesn't belong in prison. So I think the first sentence of the statute of subsection 10 takes care of the legislature's worry about violent felons, but yes, of course.
I will tell you, I'm with Justice Lawson. It's a bit of a hard sell for me to say that, where the legislature specifically put in language for those that are dangerous, and also understanding that there may be some who are dangerous who are, for whatever reason, are not captured in the forcible felony or in those exceptions that are there. And given that, it'd be hard for me to say that we're effectuating the legislative attempt by completely striking that and giving no remedy at all, where there's another perfectly good one that seems to do all of those things.
Of course, and that second option is there too. But I think it's also important to recognize, the legislature at any time since 2009 could have lowered that point total. And they could have said, we want people 20 points, less than that. They could have added more statutory exceptions. Right now we have the forcible felonies and the third-degree felonies under Chapter 810. They could have put other ones in there. The legislature didn't think that was a problem at the time that it was written, and I think the lack of legislative action and since of adding more felonies. I think the primary purpose, it's to save money and it's to take away the trial court's discretion. So, of course, we would be happy with that second option as well, but I think the violent felony offenders that Judge Makar was worried about too, below, I think the statute precludes that. Just the first right on the plain words of the statute precludes those people from getting non-state prison sanctions in the first place. I'll reserve the remainder of my time for rebuttal.
May it please the court. Quinn Humphrey, behalf of the state of Florida. First, this issue is moot. The defendant, the petitioner, was released from prison in December 2018. And this court previously answered the question in Brown in December of 2018 as well.
What about the collateral consequences of the prison sanction?
Anything that everybody's anticipating that he's going to be PR'd back in prison. We don't know that is going to happen. This may be the push he needed to be rehabilitated and serving a non-state sanction to lead a lawful life.
If he were arrested, say, next 3 years, PR, if he's arrested and convicted within 3 years of his release, it applies, correct?
Yes, Sir Honor.
And then the judge has to give the maximum statutory minimum and that kind of stuff. Bad things happen. So let's assume for a second that he gets arrested and convicted in the next 2 years after his sentence. How would he raise that this statute was not properly decided? This case was not properly decided.
What he could do is he would look at his sentence at that point and argue that it raised any issues that he has in his present case. The fact remains is that it is well settled that when you have completed your sentence, you can't go back and revisit it.
Absent collateral consequences.
Absent collateral consequences.
You would agree with that?
Yes, Your Honor.
But there seems to be a few here, so PR is one of them.
Potentially.
But the other one is, forget even just if he's arrested again and it's PRR, let's say it's not a PRR qualifying offense for which he's arrested, or let's say it's further down. This scores higher because of what he got, correct?
Potentially, Your Honor.
Right. So, I mean, this stays with him for the rest of his life, does it not?
Yes, Your Honor.
So how is it not, as to this particular defendant, moot whether he gets 1130 or 4 years in state prison?
It is. The fact remains still that he was convicted of a felony, that he's going to get points from that regardless. And it's the fact that assuming that he would reoffend, we don't know that. Then it may cause an issue for him, but it may not. We don't know. We're speculating at this point.
We're frequently not going to know exactly how collateral consequences may play out.
Collateral.
Isn't that the case? That's kind of in the nature of it. Depends on what happens.
And there could be potential collateral consequences. There could be, very well be, but the fact remains that just like in Brown, this court the prior incarnation of this court refused to consider a possible remedy because Brown was released at the time during the appellate process. We had the exact same situation here. This case came up in the pipeline with Brown, and the defendant was released during the appellate process.
So we know it's capable of repetition and capable of, once again, evading review.
We don't know that, Your Honor.
Well, of course it is.
Well, the problem is that when this case and Brown came up at the same time, Brown came in the 5th, this one came up in the 1st. And the big question was, does Apprendi, Blakely, and his progeny apply to 7750E2 subsection 10? This court answered in Brown, yes. What we have here now is we have a case that's in the pipeline, but we don't know if it's capable of repetition because we have yet to see the effect of Brown percolate up from the trial courts through the DCAs to see if there is in fact an issue that's worth remedying. We don't know. There may be defendants, there may not be defendants that have to face this issue. Brown and Booker both came up at the same time. I mean, the first question, the certified question of great importance is unconstitutional as applied to Booker? We know the answer to that is going to be yes. And the second issue, he is out. Using the logic from Brown and from prior court decisions, we know the issue is not going to be able to be resolved at this point.
Well, and the issue that the legislature apparently was most concerned about was the year-and-a-day sentences that I'm pretty confident were routinely being given and transferring costs from from the counties to the state to house inmates on these lower-level felonies. And if that continued, it would never be reviewed, correct?
Well, Your Honor, that with the first question resolved, we now have a much more streamlined process to go through on appeal. And so it can reach the District Court of Appeals and be handled by them appropriately before and then potentially
except
by
under the
Supreme
first
Court.
district court's decision, there's no remedy anyway. So there's a constitutional violation with no remedy.
Well, the first District Court of Appeal did reach a remedy in Booker, which was statutory revival. And looking at the array of remedies before the court, the remedy that does not work is the one the defendant repeatedly advocates for, which is to strike the second sentence of 775-082 subsection 10 and create an open field where everybody gets a non-state sanction. When you look at the Florida Senate bill analysis and fiscal impact statement, under subsection 3, the effects of proposed changes, it says, Section 1 amends 775-082 to require the court in certain circumstances to sentence certain non-scoring offenders convicted of a third-degree felony to a non-state prison sanction.
We don't have to look at the legislative history to make that call, do we? I mean, it's in the statute itself.
It's in the statute itself, but it further buttresses the fact that you can't sever these two sentences. It is one structure. If you score less than 22, you're not committing a burglary or trespass under 810, and it's a nonviolent offense, you get a non-state sanction unless you're found to be a danger to the community. In Brown, this court, the prior incarnation of this court, found that determination needs to be made by a jury. When the constitutional issue is the fact that you did not impanel a jury in the first place to make a fact finding, then the remedy on reverse and remand is to impanel a jury to make that determination. And that's the remedy we're advocating here. That if it reverses and remands, if the state chooses to impanel a jury, there's attorneys involved. This court would use an inheritance authority to make a jury instruction and a verdict form. The state has to hold its burden beyond a reasonable doubt. And at that point, if the state does meet its burden, that if the trial court would then may impose a sentence that is in line with the jury's decision, but it is bound by the determination of dangerousness. That gives effect to not only Brown, but it gives the petitioner and other defendants the greatest possible constitutional protections available to them. If there are no further questions, then I would ask this court to find it moot, and if not, to allow, in other future circumstances, to allow a jury to be impaneled by the state, if they choose, to make a determination. Thank you.
Thank you. I'd like to briefly address Justice Luck, the second remedy that we've advocated for in our brief. I'd like to talk about the Del Val case briefly. I cited it for the proposition that this case is not moot in response to this court's order about the motion to dismiss. But in Del Val, you had an issue with a probation statute, and this court said, if we can look at this statute, if there's any way we can apply it constitutionally, in Del Val, the issue was what wasn't in the statute, and it was the fact that the trial judge, it didn't exactly say that they had to make an inquiry of the probationer that they could afford probation. And so this court said the legislature was clear with what they wanted to do, and we can look at this constitutionally by reading into it the fact that, or the the ability to pay. And this court upheld that statute to give due process to the probationer, but to also give effect to the legislature. This court could do that in this case, particularly because Apprendi was already decided when the legislature wrote the word court instead of jury.
It just seems like we're already doing this. So think about the guidelines. When the score sheet came out, we weren't having jury findings if this was a domestic violence case or this was a case that resulted in sexual contact. Those things weren't found. But now we're including those as part of the verdict forms, right?
Yes.
It wasn't part of the statute. It still isn't part of the statute. It doesn't say these things that increase the score must be found by a jury. Mm-hmm. We're just doing it, right?
Yes.
It seems that all we have to do is that here, which is just require that juries make these findings, or else it's unconstitutional.
Yes, and I think, again, the jury making the finding of potential future dangerousness to the public, that's only going to be a few cases because many of these defendants, they have low points. These are not very serious felonies. Maybe they can't afford a bond and they're going to take a plea. So many of these, there could be a stipulation.
I'd like to clarify the relief you are now seeking for your client in this case. Do you want just simply an answer to the certified question, or would you wish your client for some reason to be resentenced with a jury trial? Where are you at on the relief for your client?
For
in this
my
case?
client, there is no relief. He's done his sentence. He's out.
There's
I'm
no
still,
collateral relief that you want somehow some other proceeding to address for your client in this case?
he might have something in the trial court in a post-conviction motion.
But doesn't that mean then, it seems like this whole collateral consequences thing is what might save this from being deemed moot, but if there's not going to be a resentencing, then if you're saying that there's nothing more that can be done, then I don't understand how that helps you.
In terms of the second,
Assuming we go with option 2.
Sure. And I'm
It
conceding.
could, you're saying it could impact other people, but not your client in this case?
Correct. And
But
that's
yes,
why.
Then that's not a collateral
Right,
consequence
but yes, it
issue.
could. I mean, that's the whole point. That was the point of the question here, which is
Sure.
if your client goes through a jury, assuming that we vacate the sentence, the state decides to go ahead, and they can't prove it, and your client gets 1130, that's a benefit to your client, is it not?
Yes.
You just don't want to risk the 5 years, right?
Well, assuming he's going before the same trial judge,
Assuming all of that. You don't want to risk the 5 years, right?
I wouldn't want him getting more.
I understand. That's the issue. So I guess what Justice Polston and I think Justice Muniz and the Chief are asking is, don't you have to fish or cut bait? In other words, you can't have it both ways. It's either not moot because there's collateral consequences, in which case you have to advocate for a resentencing, or it is moot because your client served a sentence and there's nothing more that anyone can do here, right?
For the second option?
Yes.
But again, I'm advocating for.
I know, but for the second option.
I don't think he should have had anything in the first place. So if he was remanded to the lower court, if this said, okay.
What happened what happens afterward? Whether there's going to be, what the nature of the proceedings would be if we find that the state would be entitled to impanel a jury. That's something that would be, you'd have to talk with your client about, and you talk with, and then that would be worked out then, right? I mean, does that have to be decided now?
Yes, I would have to consult with my client. But again, the sentence that he already received, this illegal sentence, this unconstitutional sentence, it's done. In terms of the collateral consequences yet, but I don't think that if this court decides the option of let's have a jury decide these issues, he's done. I don't think he's going back and getting more.
What was the last thing you said? If we decided a jury trial is appropriate, what?
A jury would be appropriate to make the finding of dangerousness to the public. Of course, again, I'm saying that anything for any person under 22 points, this court should uphold the intent of the legislature and say, even for people who already finished their sentence and all the ones that we're getting in the future, they shouldn't get a prison sentence. They have to do the non-state prison sanction to give intent to the legislature.
But as far as having to decide this now, I mean, what's the current status of your client's sentences? Has it been vacated, or is it?
He served it all.
I understand that he served it, but
It's not vacated.
okay. So, in order to get back to sort of square one, I think. I mean, if we dismiss the case, then the sentence stays, unvacated. If we go ahead and keep the case and resolve the issues, then the sentence would be vacated, but there would be the possibility of a resentencing.
Yes.
Is that right?
And you're okay with that?
I think for my client, I don't think he's getting any more time. He's going to
But
get
you
the
understand
same.
the risk of that if he goes and they have a jury trial and there's a finding of dangerousness, the trial judge, because it's a vacated sentence, has the option of sentencing to 5 years, right?
If there's a jury trial.
Right.
Well, not this trial court. If it's the same judge,
Because they've already
that
sentenced
judge has
before.
already looked at all the sentencing options, and he chose 4 years.
Right, so assuming we sign it to a different judge.
Assuming it's a different judge
Yeah.
and assuming there's no plea worked out,
Right.
he could get 1 more year.
But may I ask a question? If we dismissed it as moot, wouldn't it go back to the first DCA's original opinion, which reversed and remanded for the sentence to be vacated as unconstitutional?
Yes, but it's done. But then, of course, the first DCA, the law is For everybody else,
No, I
okay.
understand that.
Yes.
I'm just
Yes, Your Honor.
procedurally trying to understand where
yes,
we
Your
are.
Honor. But I think the first DCA certified this question because for everybody else now in the first DCA, they're getting 0 to 5 years.
Okay.
I mean, if you're not, I don't read your argument as asking for relief for your client. So I think that in light of that, I would say that this is moot. But appellate courts consider, and this court has many times, questions of great public importance that are moot because they're capable of coming back, and this is the second one that we've had, and the state probably needs an answer. We're not deprived of jurisdiction. We could answer the question and not order any relief, right?
Well, answer the second part of the certified question, what is the remedy?
Yeah.
But no relief for my client.
Right.
Yes, this court could say the First District Court of Appeals stands. And
I mean, just because it's moot doesn't mean we can't decide the case.
Of course. I don't
Okay.
think it is moot because of the certified question.
Well,
of great
if you're
public
not
importance.
asking for relief, then it's moot in this case because,
Well, I think the supplemental authority that I cited too, and this goes to your point of opposing counsel, if this can keep happening and keep evading review,
Right.
and a lower court has said this is really important, we need it decided for all these defendants who are similarly situated
Yeah, I
going
understand.
forward. As long as it's that certified question of great public importance, it's not moot. We need a resolution. So if your honors have no further questions, I'll conclude by saying this is the case to decide this issue. The certified question that the first DCA thought was greatly important needs to be decided, particularly because right now, the thing that the legislature didn't want is happening again. People with under 22 points and under are getting prison sentences now, and the rest of the state needs guidance on it. Again, I would ask that the court sever the unconstitutional part of the statute. If the legislature decides it wants to create a constitutional safety valve provision, it could. Otherwise, the second one, and both of those options would honor the intent of the legislature. Thank you.
Thank you both.
We thank you both for your arguments. The court will now stand in recess.
All rise.